Good morning, ladies and gentlemen. Welcome to the Catalyst webinar series presented by the Education Committee for the Southern California PGA. The Catalyst webinar series is a bi-weekly educational platform for creating success and change in your club and career. We are very proud and excited to welcome Mr. Van Goodwin. He is a partner and a shareholder with Littler Mendelson. They are an employment law firm that specializes in wage and hour, government contractors, discrimination and harassment, labor management relations, construction, and the Littler Construction Industry Toolkit. Mr. Goodwin, good morning. Thanks for being here on the Catalyst webinar series.
I'm happy to be here. Thanks for inviting me. All right, so off to the races.
Yes, sir.
Here we go. There we go. All right. Well, be patient with me. Good morning, everyone. We're going to spend about the next 45 or so minutes together chatting about sort of new developments. And the topic I chose for the day was New California Employment Laws 2020. Some people are calling it 2019, but since these laws won't take effect until 2020, I thought 2020 would be a more accurate label. And I call it more cowbell for those of you that understand that concept. And for those of you that don't, then you got to watch more Saturday Night Live because it's all about more cowbell. This is my shameless face. As indicated, I'm a shareholder in the law firm Mendelson. We are the world's largest labor and employment law firm with about 1,500 lawyers worldwide, about 12 offices in California, all over the U.S. And all we do is labor and employment law all day, every day, 24/7. So everything from, and we only represent management and companies and employers. If we don't represent individuals per se. So I'm in the San Diego office, and I will try to run through the program. So here's the deal. What's new in the Golden State? We still call it the Golden State until it falls off into the ocean or burns up. But it's still the Golden State, and that's what we're going to continue to call it. So what's new in California this year? Well, we have a new governor, and with a new governor, things change. And, you know, Governor Newsom is the former mayor of San Francisco, former lieutenant governor under our previous governor. This will be the first successive Democrat-to-Democrat governorship in California since the 1870s. So over 100 years before we really had this phenomenon. So that will make for some interesting changes, I think, we see. And we've already seen one of the new things that's happened with our new administration, and that is this year, we've had 40 new employment-related bills that have been signed into law by the governor, and it's clear that this is going to be one of the more challenging employment law compliance years ever. So buckle up and stand by as we go through this process. Here's the agenda. We're going to talk a little bit about independent contractors, and that is kind of the number one issue on the table. Arbitration, for those of you that have arbitration agreements with your employees, this is also a big topic today. Privacy rights, another new law that got enacted. Harassment training, some good news there. Lactation accommodation if you have female employees. Employment discrimination law changes. Some no rehire provisions that you're not going to be able to include in your separation agreements or settlement agreements any longer. Hairstyle discrimination. We're in California, so all we do is keep adding things to protected statuses, and hairstyle discrimination is the latest. And then we have some wage and hour discussions, and then leave of absence, and then somebody's favorite topic, not mine, the weed workplace, because that's kind of a new change as well. So let's start off with the independent contractors. Independent contractors have been, you know, kind of a well-recognized group of individuals who have been utilized in a lot of different places in a lot of different ways for a long time. Obviously, in the construction industry, very common, but outside the construction industry, even in your backyard, you know, independent contractors are not unknown. A lot of the golf pros, a lot of the other kinds of people that are used in the recreation industry, you see a lot of independent contractors. Well, a new day has dawned because with the advent of the gig economy, the whole independent contractor relationships have been under attack, and that's clearly what we're seeing now with legislation. So as of January 1, we're going to see a major change. January 1, 2020, 2 million independent contractors will become at least considered to be independent employees under California state law. And as employees, these people are going to be the beneficiaries of all the state, city, municipal workplace laws and regulations that apply to them, wage and hour laws, discrimination laws, the whole 9 yards. Well, okay, what's the big deal? Well, under this bill, AB 5, there's a real potential for litigation over failure to classify people appropriately. What kinds of claims are going to be brought? Certainly failure to provide wage statements to these individuals like you would for your regular employees, failure to pay overtime because now these people are eligible for overtime minimum wage, failure to provide meal and rest breaks because obviously they're employees, they're entitled to those things now, waiting time penalties, failure to reimburse business expenses, and then of course PAGA penalties. Those of you who don't know what PAGA is the Private Attorney General's Act. So it now deputizes all attorneys in the state of California to represent employees in lieu of the labor commissioner and file claims on their behalf, as opposed to requiring them to go through the labor commissioner processes. So a lot of things are going to happen. So a lot of this, again, was caused by the gig economy, and there was a Supreme Court case that came out last year called, depending how you pronounce it, it's either called Dynamex or Dynamics, and Dynamex sort of changed the rule that we've all operated under for, I've been practicing law for almost 40 years now. And the law in California was based upon an old case called Borello, and it was really kind of a one-part test that had a lot of different moving pieces within the one-part test. Now, under Dynamics and AB5, which institutionalizes or statutorily adopts the Dynamic standard, we see a dramatic change in which the law is going to be adopted. So first of all, we're going to adopt the ABC test. And I'll talk a little bit about what the ABC test is. Secondly, there are some exceptions. If you're fortunate enough to fall into one of these exceptions, congratulations to you. You'll see when we go through them, a lot of these exceptions were due to, shall we say, a fair amount of lobbying by various organizations that were able to get them some relief. And then last but not least, for those of us that are lawyers, and unfortunately for those of you in the employment sector, we're going to see a lot of potential claims and lawsuits that are going to be filed, and the statute specifically authorizes private and public actions to enforce the new law. So here's the ABC test. Pretty simple. If you claim, and you have the burden of proving now, the statute presumes that everybody you work with, you hire, you retain, doesn't even work for you, is an employee, unless you can demonstrate that this person qualifies as an independent contractor under the ABC test. So the first part of the ABC test, and the word AB and ABC doesn't stand for anything other, it's a three-part test. A, the worker is free from control. Now the control aspect, it was something that's been part of the process for, as I said, under the old Borello case for a long time. That's not new. The B and C part are the big challenges. The B part is the worker performs work outside the usual course of the hiring entity's business. I'm going to pick on golf clubs for the moment. So you're a golf club and you hire golf pros, and these golf pros are independent contractors. Are they? Because aren't they working in the same course of business as the hiring entity's business, the golf industry? That's going to be a hard row to hoe. So this is going to become a challenge, I think, for a lot of institutions that are used to hiring individuals to do certain kinds of work. Then the C test, the worker has to be engaged in an independently established trade, occupation, or business. And again, picking on the golf pros a little bit, maybe that's an argument if there really are truly independent trade, occupation, or business, if they're licensed, if they're registered golf pros, all those sorts of things. Then we have at least an argument. But we still have the B test to deal with, and we also have the C test. So let's talk about the elements of the different tests. The A prong, it's the right of control, not just the exercise of control. If you tell somebody when they have to come to work, how they have to dress, what they have to do, things of that nature, then we have the right of control. That's going to be a failure with regard to the right of control test. Again, this is the same test that's been in place for a long time. The B prong is the bigger challenge, I think, for a lot of entities. And the good news is for California, we only adopted one of the two possible. Other states have gone on a two-part B test. It's outside the usual course of business of the hiring entity or outside the place of business of the hiring entity. Obviously, if it was outside the place of business of the hiring entity, that would be an impossible test, I think, for a lot of organizations in your space to be able to occupy, because they come to work and they're working generally in your place of business. So that would be an impossible burden. But establishing that they're outside the business of the hiring entity, that's still going to be a big challenge. The Ctest was the C-prong rather, was the individual self-employed before performing the services. Do they have business license? Do they advertise? Do they offer services to other customers or other places of employment? These are the kinds of things we're going to be looking for if we're going to be able to establish the independent contractor relationship. And it's not just about, what we think is the general issues for employment law, which is the wage and hour laws. Obviously, we're going to have employment discrimination laws that apply to them. We're going to have all the different aspects of the labor code, unemployment insurance. These folks are not going to be eligible for unemployment insurance, the California wage orders, which is the wage and hour stuff, and workers' compensation. Effective July 1, 2020, this particular test will be applicable to the Workers' Compensation Appeals Board, and individuals are going to have to be looked at by the WCAB if they were previously independent contractors. The view might be very different by the WCAB and the ALJs that are administering the workers' compensation statutes. So it's going to be a big deal. Well, what are the exceptions? There are specific businesses and folks that can be exempted. Professional services, real estate, business-to-business entities, construction industries, referral agencies, motor clubs. I don't see golf clubs. I don't see tennis clubs. I don't see those kinds of entities listed among those. Likewise, you don't see, the gig economy indicated here. So there's a lot of areas in which there wasn't any recognition of any kind of exceptions that were being given. But look, this is the problem. This was kind of a rush job, and what happened is, a lot of people got some benefits, but not as many as people would like. So, this is the vice chair of the committee, a quotation from him. And if you look at the carve-outs, the exceptions, and you look at the winners and losers, you can see that it's really not clear how and why certain individuals got certain benefits, who got favoritism and who didn't. So this is going to be an extended process to see if some additional changes might be wrought during the course of the next year. And certainly entities like Uber and Lyft and some of the other entities are certainly looking at ways in which they can, amend the statute and get themselves some benefits. So the ABC test for the wage orders is retroactive. It's currently in place. So a lot of the wage and hour stuff already in place. The ABC test for the California Labor Code, which provides for a lot of other wage and hour laws, meal and rest periods, things like that, and employment law applies effective January 1, 2020 for workers' compensation, as I said before, July 1, 2020, and then the 7 categories of exceptions apply retroactively to the extent permitted by law. What that means, none of us know. We'll see as this plays out. That's the sad part. The enforcement, an injunction is permitted by the state attorney general, the city attorney, or the prosecuting attorney in the county in which the complaint is filed, or upon their own complaint, the name of the people, or upon complaint. This is PAGA land, basically, when we talk about this third kind of option. So we're going to see all kinds of different things happen here. The goal here appears to be to get around arbitration agreements. That's one of the things that is the clear design here. Well, why are arbitrations such a bad thing? Well, a lot of employee groups, unions, actually don't like these arbitration agreements for unrepresented employees. In addition, arbitration agreements have been fairly successful in California of being able to avoid class action litigation. So the goal is to take that argument away and to put people on a playing field that gives them the right to bring their lawsuits or the state attorney generals to do so. So again, this is Lorena Gonzalez, who was the author of AB5, and her comment was, again, confirming kind of a rush job. We probably won't fix it for everyone at this time. We just ran out of time, and she's never worked harder on a bill, spent more hours on a bill. And yet we're not going to get every situation we dreamed of. And she anticipates working for the next few years trying to get a solution to all these problems. So I think that's a good sign that there will be some continuing effort to try to get some modifications to statute that will enable it to be a little more employer friendly. But for now, it's a crazy world. So what are your options if you're looking at how to solve the independent contractor problem that you may be facing? One is audit and assess your workforce. Can you qualify these people as independent contractors or not? Knowing what the burdens are into the ABC test. Look at all your 1099s for the last 12 months, because if they're 1099s, that's generally independent contractors, and that's certainly a period of exposure for the retroactive aspect of Dynamex. You qualify for one of the exceptions for AB5. If you do, great. Are you actually classifying your workers on the ABC test? If you don't know, we have a great program, and of course, lawyers like myself and my firm do a lot of this analysis, and we have for a long, long time. But we have a partner we work with, or a firm called Compliance HR Navigator IC, and they have a great software program that they can roll out and plug in, and they do a great job of being able to decipher whether or not your folks are truly independent contractors or not. What's next? Well, I mentioned a little bit in passing arbitration, and arbitration has been under attack in California for 25 years. Countless challenges by employee groups, and the California Supreme Court has been very, very reluctant to approve of arbitration. They're always looking for ways to carve out exceptions to it. On the federal side, for 25 years, we've had the U.S. Supreme Court ruling consistently arbitration is the law of the land. It's a good thing. We can have class action waivers. It's all great. So what California has done now is they've enacted a new labor code section. It's 432.6. No mandatory overtime is permissible in California now. You may not require that employees arbitrate claims for alleged violations of the Fair Employment Housing Act, which is discrimination, or the California Labor Code, which is generally wage and hour laws, as a condition of employment. You can't do it. And you can't retaliate against people who refuse to waive their rights to under an arbitration agreement. So what we used to use, and what a lot of companies were doing, was opt-out provisions. If people don't want to be bound by arbitration, they can opt out of it. And the AB 51 says that is not going to work anymore. It just isn't possible. So this applies to agreements entered into, modified, here's the curious word, or extended on or after January 1, 2020. And then elsewhere in the statute, it says this doesn't apply to arbitration agreements that were entered into prior to January 1, 2020. So what does extended mean? I don't know. I certainly think that if you're hiring new people and you're going to use an arbitration agreement for those new people after January 1, 2020, you're going to have to be looking at AB 51 in terms of determining how to best apply. For those of you that have current agreements and current employees that are covered by an arbitration agreement, you're going to have to make some hard choices. Either you're going to have to acknowledge that we don't want to have arbitration anymore and do away with it, or we're going to have to sit in the sidelines and watch this thing develop a little bit more and argue that simply because we have arbitration agreements and they apply going forward in 2020, that isn't, quote, extended. That's something else. I don't know what verb we're going to use to attach to it, but it's a curious word that we're not really sure what it's ultimately going to be interpreted to mean. Obviously, though, if you modify or revise an arbitration agreement after January 1, 2020, that is clearly going to be something that's going to come into play. So here's another big exception. As I mentioned, the U.S. Supreme Court has been very consistent and, dumped on the California Supreme Court many times now in the last 5 or 10 years because these arbitration agreements are considered to be protected under the Federal Arbitration Act, the federal law. And for those of you that don't recall civics from high school or college, there's this thing called the Supremacy Clause in the U.S. Constitution. So things like the Federal Arbitration Act, which is a federal law, supersedes and overrides any inconsistent state laws. So we have this, and the statute recognizes that nothing in it is intended to invalidate an arbitration agreement that is in fact enforceable under the Federal Arbitration Act. What does that mean? It means we're going to have a lot of uncertainty for a period of time, and maybe your particular arbitration agreement might be challenged to determine whether or not it truly falls within the penumbra of the Federal Arbitration Act. A lot of uncertainty, unfortunately. So last year at this time, the identical bill, almost identical bill, was introduced. It was introduced 2 or 3 years in a row, but the identical bill last year was presented. And Governor Brown vetoed it, saying this bill plainly violates federal law, the Federal Arbitration Act, and he wouldn't sign it. Well, new sheriff in town, and that didn't happen with the new governor. But Governor Brown did sign last year a bill called SB 1300, which prohibits an employee from employer from requiring an employee to waive any claim or right under Fair Employment Housing as a condition of employment. Well, what does that mean? That means if you release a claim, that might include the right to file a lawsuit. Certainly, if you're waiving any rights you may have to bring those claims, that's going to be another phenomenon as well. Well, here's the weird thing. The statute was enacted last year, which is Labor Code Section 432.6, provides as follows. 433 provides any person who violates any provision of this article, and 432.6, which is the anti-waiver provision, is in Article 3, is guilty of misdemeanor. So what's that mean? It means that if you choose to have an arbitration agreement in effect in 2020, you're guilty of a misdemeanor. Shame on you. There are penalties associated with that. Is a city attorney or a prosecuting attorney in any city or county in California likely to take an action for misdemeanor against employers? It's unlikely. Probably a 1 or 2% chance. It's just not a very high probability. But it is void and unenforceable, so that is a problem. That to me is really the hang-up you have, is that a court might look at this and rule that it's an unenforceable arbitration agreement, and therefore you don't get the benefit of it. So what do? Let's look at options in 2020. Stop using arbitration agreements altogether. That certainly is a reasonable option. 2, implement a purely voluntary arbitration agreement with an opt-out provision. And that's certainly something that we're going to suggest clients begin to look at more seriously. There are pros and cons with that, but if you can get people to do it voluntarily, then I think you certainly have a pretty good way to do it. Continue to use your current arbitration agreement, wait for the Supreme Court to invalidate AB 51. I mean, that certainly is an option. As I said, wait in the sidelines. But beware, it is a misdemeanor, there is some risks, and you got to be conscious of that. All right, what else is new? Well, we've had some major changes to the privacy laws in California. So the latest law is called the California Consumer Privacy Act, CCPA. And CCPA, the basics are a business, and this is not new really, a business must protect the private information of a consumer. And a consumer is a natural person who's a resident of the state of California. So need not be a customer of business. It can be anybody who is a California resident who you do business with. And it clearly includes employees of business. So a long way around saying this, employees are certainly covered by this new consumer privacy legislation. Well, let's talk about the easy things in the Consumer Privacy Act. One is employees have a right of access to the information that you're storing. Okay, not a big deal. They have a right not to have their personal information sold. Doesn't sound unreasonable. They have a right of portability, that this information can be transferred from place to place and from employment to employment. Also, probably not very controversial. The right of deletion. Well, we'll talk about that in a minute. That's a potentially serious problem. And then a right to sue if their rights under the statute have been violated in some way. In terms of the actions to enforce the statute, a consumer or employee need not prove any actual injury. This is consistent with a lot of provisions in the Labor Code that are enforceable under the Private Attorney General's Act. But there's minimum statutory damages of $100 per person per incident, up to a maximum of $750. Again, looks like, walks like, smells like, probably is like Private Attorney General's Act. Well, here's the thing that's kind of disturbing, I think. At least it seems disturbing to me, and maybe you'll find it equally disturbing for you in terms of how employees might try to use this particular right, which is the right of deletion. Let's see. I got my performance review, and I appreciate you rating me a 3 on my annual evaluation, but I think I'm much closer to a 4. So I'd like to exercise my rights under CCPA and delete that evaluation from your records. Now, that's crazy talk. I mean, how is an employee going to have the right to delete their performance reviews or any other personnel document that you've maintained about them that qualifies under the Consumer Privacy Act? I mean, that's going to be kind of a crazy thing to do. So we'll see what happens. The statute has, kind of was adopted again, kind of in a rush this year. It was a lot of things that happened fast. Here's some potentially good news. Personal information doesn't include publicly available information. Okay, publicly available information means information that's lawfully made available from any federal, state, or local government laws. Okay, well, that's not particularly controversial. AB 25 excludes the definition of personal information 3 categories of employment information. Okay. HR data, personal information of California residents, their capacity as job applicants, employees, individuals, or independent contractors, corporate officer directors, blah, 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 blah. Workforce members is what they're called. Okay, well, personal information. Personal information, we're still not talking about that performance review. Emergency contact information, that's also not personal information. Third-party benefits information, well, that's also not going to be potentially within the scope of personal information. So there's some relief there. Another weird part of the statute, it's only good for 1 year. Again, adopted in a rush, just to get something on the books. And it's designed to, this 1 year period, designed to give everybody kind of a free look. Let's see what it looks like. Let's see if it can be revised, modified, tailored more closely to make sense for everybody. So during this next year, if you're active in legislative activities, get out there and push hard on this thing, because there's a lot of features of this law that just probably are not particularly employer friendly. One of the, there's 3 different obligations that are imposed upon employers. One is workforce members must be informed as to the categories of personal information that are collected and the purpose for which that information may be used. That information, that notification has to be provided at or before the point of collection. When you hire them, when you obtain the information, that's when it's got to be done. A new notice is required when previously collected information is being used for some undisclosed purpose. So it's kind of like a data breach. If there's been a data breach, the information has been used inappropriately by any person, you've got to notify the employee, the consumer, that this has occurred, so they have rights and remedies under the statute. Businesses are liable for security breaches, including breaches of workforce member information, just like other kinds of information that you're collecting from consumers. Don't ask me what the 20 controls in the Center of Internet Security, critical security controls are. I don't know what they are, but I'm told if you're in the IT industry or you're an IT professional, you'll know what these people are. So these are the standards and probably the standards of care that are going to be looked at for determining whether or not this information security has been breached and what you can do to minimize that breach. If you collect personal information other than their capacity as employees, your employees may also be your customers. So again, if we're collecting the information, we have to be mindful that if that information is being compiled and collected, then all of the CCPA's compliance requirements are going to come into play. So a big change in the world. Now, what do we do now with this law? Plan for compliance today. Get your notice postings out. Review with your IT professionals what the 20 controls in the Center for Internet Security, critical security controls are. Review them and recognize that's probably a minimum standard of care you're going to have to achieve in order to minimize your risk of liability. Harassment training. I will have some good news. It's not all bad news today. The good news is that if you recall last year, Senate Bill 1343 was enacted, and it modified AB 1825, which was enacted in 2007. And it did so in a couple ways. It extended harassment training for employers of 5 or more employees. And 5 was a very low number because it was 50 before that. So you have between 5 and 49 people, suddenly you're covered by this law, and you have to conduct harassment training. Not a bad thing, but something to be mindful of. And it was required for all employees, not just supervisors. So you had to do harassment training for all the rank and file employees and the supervisors together. And you had to do it 1 hour every 2 years as it was done for supervisors. So the required training also was required training for temporary and seasonal employees. This is another big deal, big problem for a lot of employers. Because what if they're not here? How do we do that? Well, it's only the people who are obviously employed the day you do your training, so think about the day you do your training perhaps. And that training, this training was required to be done by December 31 of 2019. Well, good news is there was all kinds of uncertainty in the old statute, so it was designed to kind of clean up some of the stuff, because if you did training in 2018, you have to be training again in 2019. My firm had a similar situation. I did the training in 2018, but I didn't do it in 2019. Do I have to do it again in 2019? Do I get a year's break? And the answer is under SB 778, employees who are trained in 2019 don't need to be retrained again for 2 years, so sometime in 2021 and every 2 years thereafter. But it doesn't change the timing of the training of supervisors. They still have to be trained every 2 years. So the December 31st, 2019 timeline for training all your employees, that's been extended now until 2021. So that's the good news. So seasonal employment training and your rank and file employees, that's going to get extended. More training has been extended for public schools and charter schools, for janitorial employees. Allegedly or supposedly, the Department of Industrial Relations is going to establish a training advisory committee to create a list of qualified prevention trainers. And they're going to do this. We'll see, but they've got a year to get that squared away. The construction industry, again, we're supposed to see the Division of Labor Standards Enforcement develop some industry prevention policy and a training standard. We'll see. Likewise, for healthcare, we're going to see all kinds of implicit bias training and some additional training requirements that are imposed on the healthcare industry. So if you're looking at this, update your training calendars to ensure you're going to be in compliance this year for the supervisors, next year for all your employees. Begin the opportunity to start looking at training for your seasonal and your temporary employees, and consider, we've been recommending this for a long time, but certainly if you have any kind of experience with bystander training, be thinking about that as well, bystander intervention training. These are people that are caught up in harassment that they witness or experience. Not always an easy thing to do, but certainly something to think about if you're going to do it. And then the latest and greatest kind of training we're seeing is what's called implicit bias training. And implicit bias training is a little controversial, but I think everybody recognizes that bias is not always, people aren't always biased and exhibit bias in a very overt kind of a way. Sometimes it's just implicitly being done. So California is heading in this direction, and we're going to see a lot of implicit bias training probably required as part of the new training regimen in 2021. That's my guess. Lactation accommodation. Lactation accommodation requirements are not new. It's been in the books now for several years in the California Labor Code. So what I've done is I've included in kind of a side-by-side chart what the old law did and what the new law now requires effective January 1, 2020. And you can see on the right-hand side of the screen, the 2020, the items in red are the new requirements. So now we're going to see a reasonable break period for each time the employee has to express milk. There's going to have to be a reasonable time offered. The reasonable employment effort standard is gone. The standard is you will do it. You shall do it. There's no reasonable effort. That's the standard. You're going to have to get it done. This is really without a change. The location is the same, more or less as it's always been, but the lactation facility or location has to be shielded from view, free from intrusion while the employee is expressing milk. A very different standard that's going to be come into play that's going to be required. It has to comply with all the different requirements for like a clean and safe and free of hazardous materials, a surface area to store personal items, a place to sit, electricity, alternative devices, extension cords, the like. Provide a sink, so you can't just put them into an office. There has to be a sink or refrigerator suitable to store milk in close proximity to the employee's workplace. If it can't be provided, some other kind of cooling capability, a cooler or something like that is going to have to be provided. There's a standard, a little standard for if you have fewer than 50 employees, then there's an undue hardship standard that can be met. But if you're more than 50, you're not going to get that break. The failure to comply requirement in the old statute, it was $100 for each violation. In the new standard, its violation was 1 hour pay for each missed meal break. My view of the world is that's actually better because 1 hour pay is probably a little less than $100 at a pop. So that's certainly some good news for my mind. The PAGA penalties, that's what this sounds like. We can see ourselves now into kind of a collective action PAGA lawsuit now for these lactation requirement violations. You must adopt a written policy regarding lactation requirement. That wasn't required before. You must provide written response. If you can't provide the lactation accommodation, you have to provide a written response to the employee as that issue. So this lactation requirement is gaining a lot of more than a foothold now. It's gaining a lot of momentum, and you're going to have to do a lot more now in 2020 than you were in prior years. So designate some of the organization as responsibility for auditing and ensuring compliance. Take whatever steps are necessary to comply with new obligations, and consider lactation accommodation spacing in your future real estate planning or when you're doing remodeling or things of that nature, because it's going to have to get done. Employment discrimination. Big change here is the statute of limitations for filing a complaint with discrimination with the California agency, the Fair Employment Housing Act, was 1 year. It's now going to be 3 years. Well, this is a big problem, because if your memory was bad enough for 1 year and your record keeping was not great, extending it to 3 years, now we're talking about if somebody files a complaint in 2020, they're going to go back to 2017. So 3 years back, memories may be harder to revive. Documentation may not have been well maintained. Things could be dramatically different. Another weird part of the statute says it will not be interpreted to revive lapsed claims. What does that mean? Well, that means that if a violation occurred in 2018, that the 1 year statute of limitations applies to that, and then 1 year from that date to file a complaint. So filing in 2019. What about the violation occurred in 2020? Well, then the 3 year statute of limitations applies. That's easy. What if the alleged violation occurred in 2019, like January 10th? I just picked the date. Well, as of 2020, the 3 year statute of limitations would affect. Is this a lapsed claim that can't be revived? Well, if we look at the law and the bill analysis that's provided by the authors of the bill, it is not exactly clear, but the author of the legislation seems to believe that in that situation I described for you, that even if the statute of limitations has not yet expired, so the discriminatory harassment occurred in 2019, and you have 1 year to file your claim, which would be in the 2020, but as long as the statute of limitations hasn't expired, that the enlarged period, the 3 year period, would apply to that situation. So that is kind of an interesting development altogether. So that is a real phenomenon that's going to be hard to do. Now, is that legislative analysis going to be adopted by a court or by the agency that enforces the law? Don't know. Sometimes courts accept legislative history, sometimes they don't. If this analysis is accepted by a court, then 3 year statute of limitations would apply to claims that arose in 2019. 2018, those claims have already sunset, so there would be no extension of them. But 2019 claims, they're still out there for 3 more years. So what do we do about this? How do we solve the problem with this extended statute of limitations? We're going to have to be very meticulous about our record keeping and keeping track of information and investigations, well maintained. When you conduct exit interviews of manager supervisors, make sure that we have all their information, all their statements regarding any complaints that they were aware of or that came to light. No rehire provisions. Somewhat controversial, because most of us, when we're doing separation agreements and settlement agreements, the last thing we want is we don't want one of those troublemakers hired again. Well, we can't do that any longer. Last year, the case came out that said it cast a lot of aspersions upon these no rehire clauses, suggesting that they were consistent with kind of a unfair competition to impact people's ability and freedom of movement. Kind of a tortured analysis, but nonetheless, the law was out there. Well, the legislature's picked up to that and now indicated that in the statute that you cannot include a no rehire clause in a settlement agreement of an employment dispute with an aggrieved person where the employees filed a claim. Well, if they haven't filed a claim, then we have a reasonable argument. So clearly, as part of a basic separation agreement, maybe we could do that. Maybe we could do that. So it's still acceptable to have that language when in the context of an end of employment relationship, a severance agreement, for example. So you can also have it if it's determined that the person's engaged in sexual harassment or sexual assault, and that's part of the process. You can also include it if there's a legitimate non-discriminatory, non-retaliatory reason for terminating the employment relationship or refusing to hire the individual. So what are the suggestions? Don't include the new hire provisions in settlement agreements. I don't include them in the settlement agreements. I don't include them in severance agreements anymore, but I'm going to look at doing it now. And you get to factor in the settlement value of these no hire provisions when you're resolving these kinds of claims. But what you could do, I think, is you can consider a couple of different provisions in your agreements if you really want to have that no rehire language. One is you can specifically state that you have a legitimate non-discriminatory or non-retaliatory reason for refusing to hire the employee and put that right in there, and that may get you a little bit of headway. Or you might be able to establish that you have a good faith belief the employee did engage in sexual harassment or committed sexual assault, and that takes advantage of the situation there as well. So there are some opportunities. Again, as I've said, California is always at the forefront. We always want to adopt more and more things to fall within protected characteristics. So the latest is hairstyle discrimination. This is known as the Crown Act, creating a respectful and open workplace for natural hair. So this extends the definition of race that's recognized under the California Fair Employment Act as a protected characteristic to include both hair texture and protective hairstyles that are closely associated with race. So we're talking about braids, locks, twists, those kinds of things. And it's not an exhaustive list. It can be a lot of things. And the statute was designed because workplace dress codes and grooming policies that prohibit natural hair have a disparate impact on Black individuals, as those policies are likely to deter Black applicants, and the burden to punish or deter Black individuals from being employed seems to be pretty pronounced. So the statute has at least a legitimate social purpose of trying to limit that potential source of discrimination. So it prohibits discrimination based on a protected characteristic, hair or hairstyle. It prohibits discrimination because the person is perceived as having a protected characteristic. Perception is almost the same as having it. Here's another extension, though, that is kind of more troublesome. Prohibits discrimination because a person has an association with someone who has or is perceived to have a protected characteristic. So if we have employees that kind of hang out together and we discriminate against one of them because they hang out with somebody who has a protected hairstyle, or if it's a Caucasian employee that uses braids, something like that, we also have protected characteristics as well. So we have real developments here. One good news is that the Fair Employment Housing Act exceptions for bona fide occupational qualifications and security regulations may still apply. I don't know how well these are going to stand up anymore, because more and more we're seeing people that are able to function in a lot of different areas of employment, from with hairnets and with you look at football players and basketball players. I mean, we see a lot of athletes that are able to function with hairstyles that probably we didn't think would probably work out particularly well in years past. We're seeing more and more of this being recognized. So I'm not sure this is a great standard, but it's out there for your benefit if you want to use it. So what should you do? Review your dress codes, grooming policies, and hiring practices, and update them as necessary. Start training your people to be aware of the sensitivity they need to have to do it and their day-to-day responsibilities. Wage and hour laws. So I'm going to skip through this because I don't really know that it applies to you. The materials are going to be available to you. I think that's something we're going to do anyway, but I'm going to skip through this because it really has a very limited application to certain kinds of employers, and I don't really see this as being applicable to your industry. Leave of absence regulations. The current leave of absence requirement is 30 days for organ donation. An additional 30 days of leave is under the new statute. SB 83 extends from six weeks to 8 weeks the duration of paid family leave that can be taken under the SDI program. And that's a bit of a misnomer, because the statute doesn't really guarantee people a right to take leave. It says they can get benefits put through the SDI program during that period of time, and they may be able to take leave of absence, but it's not obligated necessarily. This becomes effective July 1, 2020. And this kind of leave, this paid family leave, is available to take care of a seriously ill child, spouse, parent, grandparent, or the like, or to bond with a minor child within 1 year of their birth. So an extension of them. All right, here we are. We're at the weed workplace, and I know that's what everybody in the room was anxious to participate in and hear about. I don't have that much to offer, other than if you're looking to be in the cannabis business, then the world is going to change for a lot of those industries very soon, because the cannabis business, if you have 20 or more employees, you're obligated now to enter into a union contract or what's called a labor peace agreement. And a labor peace agreement is one in which the employer agrees not to resist union organizing by its employees. So you basically agree, we'll take a step back and we won't have anything to do with that process. And if they want to organize our workforce, they can do so, and we're not going to get in the way. Kind of a surprising twist, but who knows what the real purpose behind this was, but it will now be the law as of January 1, 2020. So a few concluding remarks. Clearly the independent contractor issue is a real big issue to start looking at. So start auditing your 1099s, work with your IT professionals regarding those 20 controls. We're dealing with the consumer privacy rights. Look at your harassment training timeline to make sure on board of that. Start thinking about lactation accommodation requirements that are going to have to be dealt with. You're going to have to do a better job with your exit interviews and documentation to address the 3-year statute of limitations for discrimination. And just hang on, because 2020 is coming fast, and we got a lot of things to take care of in the next couple of months. And then 2020 is a new legislative session, and who knows what's going to happen in the next session. That's all I got.
Thank you very much, Mr. Goodwin. We have a few questions that have come in during the presentation.
Okay.
If this comes in from Andrew Warren. If I am living and working in California for a company based outside of California, and they are bound by CCPA,
Are they bound? Are they bound?
As it relates to me?
Yeah. Answer: probably yes. Probably yes. Because most California residents, if they work for a non-resident employer, are subject to regulation under California law. So the answer is probably yes.
And in terms of independent contractors, does the average hours of work per week make a difference in how they're categorized?
I don't know what average hours of work per week, because if these people are reclassified from independent contractors to employees, then they become eligible for, among other things, overtime after 8 hours in a day. They have to be given meal and rest periods. They have to be given paychecks on a regular basis. Their paychecks have to meet certain requirements. And if they work more than 8 hours in a day or 40 hours in a week, they're entitled to overtime.
And those are all the questions that we have on this morning's Catalyst. On behalf of the Education Committee for this, excuse me, on behalf of the Education Committee for the Southern California PGA, we'd like to thank Mr. Van Goodwin of Littler Mendelson for his time in presenting to the section this morning. Thank you very much, sir.
Thank you very much.
As usual, the Catalyst quiz will be going out to all the registered email addresses on this morning's call. Please take the quiz and return it to Sharon Kerfman at skerfman@pgahq.com. A score of 70% or higher will earn 1 MSR credit for attending this morning's Catalyst. There'll also be a YouTube recording on the PGA, the SCPGA's YouTube page. Feel free to reference the YouTube recording when taking the quiz. Thanks again, Mr. Goodwin, and have a great day.
Thank you very much. Thank you. Bye-bye.